Welcome everyone, and thank you for being here. I also want to thank the wonderful staff of the New York City Bar Association, the co-sponsors of this event, 14 hardworking groups who are listed in your program, each of our outstanding speakers, and our distinguished moderator, Bridget Bergen, who is Senior Political Correspondent for WNYC and Gothamist. My name is Catherine Loving, and I am Chair of the City Bar Election Law Committee. And I especially want to thank you for being here. An amazing group of experts has gathered tonight to talk to each other and to you. Let's listen. Now, to begin the evening, it is my great honor to introduce the president of the New York City Bar Association and a partner at Arnold & Porter, Sheila Boston.
Good evening and Happy New Year to each and every one of you under the sound of my voice. I hope that each of you are doing well and will make sure that 2022 will be a year when you will pay particular attention to your mental as well as physical health, as we are still unfortunately in the midst of a pandemic. But take heart and believe that this is going to be a great year. And I wish for each of you good health, joy, peace, and prosperity. Now, for those of you who may not know me, my name is Sheila Boston. I'm a litigation partner at the law firm Arnold & Porter. I'm a mother, a wife, a sister, a daughter, a concerned citizen of these United States, and I am proudly currently serving as the president of the New York City Bar Association. And it is my pleasure to welcome you to our program this evening, New York, Texas, an election reform conversation. I wish to express a tremendous amount of appreciation to our Election Law Committee, and especially to its chair, the one and only indefatigable Catherine Loving, for pulling this program together. Also, a big thanks to our co-sponsoring committees and all of the co-sponsoring organizations, as well as to Bridget Bergen for moderating, as well as to our wonderfully esteemed panelists. I most especially wish to extend a big, warm New York welcome to our friends from Texas who are joining us this evening. Or perhaps I should have said, howdy. Seriously, what a brilliant idea this is, bringing together folks from separate states to discuss election reform. While all elections, even national ones, are local in their administration, a huge lesson of the last presidential election is that Georgia's business, and Michigan's business, and Wisconsin's, and Arizona's, and Pennsylvania's, and Florida's business, hello 2000, and so on, are all of our business, all of every American's business. If legislators from any state can object to certification of electors by any other state, well, why wouldn't we, the people, in whatever state, support the work of fortifying the fair administration of each and every state's election? I think that it is obvious that we all have a stake in one another's state, not the least of which is because federal legislation protecting voting rights continues to face high hurdles in the US Congress. I am proud that the New York City Bar Association, AKA the Bar of Hope, which has some 24,000 members, including members in nearly every state, is using its voice, its platform to support voting rights. Last fall, we released a report called The Consent of the Governed, Enforcing Citizens' Right to Vote, which touches on many of the issues I expect will be covered this evening. And we have just launched a lawyer's pledge with 9 principles related to voting rights. And we are asking all lawyers, law professors, and law students of all political leanings to sign it. Please check it out, read it, review it. It is linked on our homepage. Please sign and spread the word about it. With that, I cannot wait to hear from our extraordinary panel, which represents a remarkable diversity of roles, including local election officials, legislators, and constitutional scholars, among others. And I hope that I'll be seeing more of these sorts of collaborations and forums where we can come together, strategize, problem solve, and make connections, and act based not on our differences or that which divides us, but instead focus in on what we have in common In this case, a love of democracy, a love for our country, and its highest values. I thank each of you so much for being here tonight. Peace and blessings to all of you in this new year of 2022. And Bridget, I want to thank you again for doing this. I now hand over the virtual stage to you, Bridget. Take it away.
Thank you, everyone. Welcome. It's always such an, I'm grateful for the opportunity to be part of these informative and instructive conversations. Before we begin, I want to introduce Stephen Cass, who is chair of the New York City Bar Task Force on the Rule of Law, a senior environmental counsel at Carter Ledyard. Mr. Cass, to you.
Thank you very, very much, Bridget. 1973 in Buenos Aires was extraordinary even by Argentine standards. A president who was democratically elected in March, but was thought by his defeated opponent to be a closet communist, was called upon to resign by a former dictator, Juan Perón, who had returned from Spanish exile. When the president succumbed to pressure from Congress, the conservative press, and the military, Perón and his new wife, Isabel, were elected president and vice president in September of the same year. Argentina's military then began a brutal counterinsurgency campaign against guerrilla forces in distant areas of the countryside. When Perón died in early 1974, his wife succeeded him as president and effectively gave the military free rein to operate against the diminished guerrilla forces and anyone else in the Argentine community whom the military regarded as subversive. By 1976, Isabel Perón was herself seen as a hindrance, and a military junta carried out a coup that made one of its leaders, a so-called president, dissolve the Congress and promised to bring security to the nation. Instead, the junta systematically began, and for the next 7 years, ruthlessly carried out what came to be known as Argentina's dirty war against anyone accused of subversive actions, contacts, or ideas. Over this period, some 30,000 Argentine citizens were kidnapped by Gestapo-like security forces, held in secret prisons, tortured, raped, and executed. The victims included union leaders, journalists, priests, university students, business owners, and not least lawyers who had either represented the others or spoken out against the blatant violations of Argentina's constitution and due process of law. Throughout this period, the leaders of Argentina's most prominent bar association remained silent. Indeed, they generally endorsed and in some cases advised the junta leaders who carried out the coup, telling themselves and others that the threat to national security from the few remaining guerrillas and opposition voices in civil society justified setting aside the Constitution, election, and independent courts. That many younger lawyers with less prominent clients who were among the victims only confirmed to bar leaders their view that lawyers too deserve their fate. In April 1979, the New York City Bar Association, learning of the growing detention of lawyers, sent a mission of 5 lawyers to investigate and report on that mistreatment and to offer any necessary assistance to our Argentine colleagues. The mission included Orville Schell, former president of the city bar, United States District Court Judge Marvin Frankel, Scott Greathead, then an assistant New York State Attorney General, and Harold Healy, and a partner at Debevoise. I was the 5th member in my role as chair of the association's Inter-American Affairs Committee. After meeting with junta officials, victims' families, and lawyers from local and national bar associations, we presented a report detailing the facts described above and concluding as follows. When governments brutalize their citizens, depriving them of life, liberty, and the pretext of due process of law, lawyers must stand for those deprived of their rights, regardless of our agreement or disagreement with their political or social views. Where the bar most directly involved is itself too threatened to act, lawyers elsewhere must speak for their colleagues and remind those responsible that humanity is extinguished, not advanced, by murder, torture, and imprisonment. If in a different time and place, our circumstances were reversed with those of our Argentine colleagues, we'll expect no less of them. Now you are asking, what has this to do with tonight's program on voting rights? But you know the answer to that. Our goal tonight is not only to educate, but to demonstrate the need for action to protect American democracy. Our Argentine colleagues are not coming to rescue us. We need to do it for ourselves. We need to speak for those who seek to vote and whose voting rights are being abridged today around our country. It is necessary for us to take action if we are to have a government which protects the most fundamental rights of our democracy, the right of citizens to choose those leaders who will represent them, to have a government whose just powers derive from the consent of the government. Silence as that right is eroded or just plain trampled is the beginning of the path that too many lawyers in Argentina followed, to their nation's regret. Fortunately, as you have just heard, our association is blessed with a president, Sheila, as well as a professional staff and thousands of members who know this risk. That is why the association has adopted and distributed its 9 principles pledge for all lawyers of every stripe and persuasion to protect voting rights in our nation. If you are moved by tonight's program, as I know you will be, please go to the association's website to find the Lawyers Pledge, sign it, join our speakers in protecting this foundation of our democracy. Thank you. And now back to you, Bridget.
Thank you so much, Stephen. And thank you for putting in stark and really clear terms how critical a moment this is for voting rights, election administration, and our democracy. I know many people on this Zoom have worked perhaps quietly in this space, perhaps loudly for many years, but to, I think, paraphrase some of President Biden's comments yesterday, I expect you too are tired of being quiet. So let's get right into talking tonight. Our first presenter is Mimi Marziani, president of the Texas Civil Rights Project, who will tell us about what this moment means in her home state. Welcome, Mimi.
Wonderful. Thank you so much for having me. You know, it is an honor to share this space with so many incredible leaders in the field of voting rights and the law of democracy. And this is also like a worlds collide moment for me. While I am very much a Texan these days, I'm a proud alum of NYU School of Law and actually started my career more than a dozen years ago at the Brennan Center for Justice. So I'm really happy to be back with lots of old friends. I am also grateful to be here because this is a really critical moment for our democracy. And I echo what Stephen eloquently said, that this is a time for action. And I know this is going to sound a bit hyperbolic, but I firmly believe the decisions that we make right now as a country may very well determine the system of government that I leave for my daughters and that you'll leave to future generations. And I believe this is such an urgent moment, in part because I live in Texas and I wake up every day confronting 3 overlapping and terrifying trends that continue to not just roll back the freedom to vote, not just perpetuate racial injustice, but also, quite frankly, erode foundational underpinnings of our democracy. And as you know, I think something else that Stephen illustrated in his remarks, we've seen this happen across the world, that just because you have a strong functioning democracy at some point in your country's history does not mean that that's inevitable. So the trends I want to highlight and then illustrate from Texas are threefold. So first, today in 2022, we're dealing with the culmination of a decade of hundreds of new laws making voter registration and voting more difficult. This is the type of thing I worked on at the Brennan Center starting in 2009, and unfortunately is continuing today. And these are laws that we've seen passed across the country, particularly making voting more difficult for people of color and other historically disenfranchised communities. This started in 2011 and gained steam and legal cover in 2013 after the Supreme Court gutted the Voting Rights Act. And that allowed states like Texas that previously were subject to federal oversight free rein to alter their election laws. More recently, those laws have been combined with similar but distinct effort to pass laws that make it easier to subvert fair and free elections. This, of course, is egged on by the big lie that the 2020 election was stolen. On top of all of that is an uptick in political violence. And this is the sort of thing that we've seen in Texas, for instance, in 2020, when vigilantes ran a Harris-Biden campaign bus off the highway, posing grave injury to the people who are inside of it. So as I said, I've had a real front row view to what this looks like on the ground. Again, going back about 10 years in Texas, starting right around 2011, the most powerful political leaders in the state have supported a range of laws and policies to make voting and voter registration more difficult. Everyone's freedom to vote has been tarnished by this, but the brunt has been borne by people of color, new citizens and immigrant families, and young people. These are all the groups that are just starting to flex their political muscle in Texas. I'm not going, I could give a whole lecture on this topic alone, but just some illustrations of what that looks like. Voter registration drives are illegal in Texas, unless and until you jump through a bunch of bureaucratic hoops and risk significant liability. That means, for instance, that Freedom Summer would have been illegal in Texas. Texas is one of the last states that does not allow voter registration online, leaving that process clunky and error prone and much more difficult for citizens to access. Our Attorney General now for years has aggressively prosecuted voters for making mistakes, including our client Crystal Mason, Black mother of 4 in the Dallas-Fort Worth area, who was sentenced to 7 years in jail for casting a provisional ballot at the tail end of a felony sentence. She didn't know she was ineligible to vote. She was told she could. Her vote was never going to be counted, but she has now been prosecuted with the full force of law behind her. In 2019, the state tried to purge close to 100,000 new citizens off the rolls. We won that case and were able to stop it, but the court went out of its way to note that the state's efforts, quote unquote, exemplify the power of the government to strike fear and anxiety and to intimidate the least powerful among us. So going into this past year, 2021, Texas was by many measures one of, if not the hardest place to vote in the country and one of the most racially unjust. And then even after, quite frankly, against all odds, we had a 2020 election that the top election official, who's a Republican, described as smooth and secure. Even after political violence reached a crescendo on January 6th, the most important leaders in our state, including our governor, lieutenant governor, and attorney general, went to extraordinary lengths to pass a new package of laws that, again, will make voting more difficult and will give fuel to those who wish to subvert free and fair elections. You know, I won't, I'm happy to talk about this later in our discussion, but I will tell you, there is only one plausible explanation for why they would do this and do it with such urgency. And that is that it's a power grab. They believe that their job security depends on an electorate that is older, whiter, and richer than Texas at large. So you're going to hear more about that new law, SB1, from other speakers, including Jerry, who's my co-counsel in litigation challenging it, Dana Devavoir, who is the clerk in Travis County. She's charged with implementing it. Representative Jessica Gonzalez, who took heroic efforts to try to stop it from going into law in the first place. just some lowlights, as it were, for folks to think about going into those presentations. SB 1 makes voting difficult for all Texans, but particularly for people with disabilities and people of color. It bans drive-through voting and extended hour voting, both of which were popular innovations used disproportionately by people of color in 2020. Imposes new ID requirements on voting by mail. It restricts the type of assistance that folks who have trouble reading English or have disabilities can receive at the polls. It imposes a whole host of new crimes, which we know the Attorney General is chomping at the bit to enforce against community groups who are engaged in get out the vote efforts. It empowers partisan poll workers who have a history of racialized intimidation in Texas, empowers them not only with new authorization, but also by making it more difficult for election workers to remove them when they're disruptive. And as you'll hear from Dana, it ties the hands of election workers in a variety of ways, including from doing things as simple as passing out mail-in ballot applications. On top of all of that, we have a new Secretary of State who is an attorney who was actually one of the attorneys who sought to challenge the results of the 2020 election in Pennsylvania, and has been overseeing baseless audits in 4 counties in Texas after Trump publicly directed that that be done. So where does this leave us? One thing I want everyone to think about is what it means to undercut the freedom to vote. This is not just offensive to core American values, and it's not just racially discriminatory, although I believe that's true. It is also self-fulfilling, because when you undermine democracy in this way, you end up protecting the people in charge at the expense of the people they're supposed to serve. And that has a self-perpetuating vicious cycle. I also don't want anyone to fool yourself to think that this is confined to the 29 million people who live in Texas. We've seen over and over in American history that regionalized problems with democracy do not stay regionalized. The Jim Crow South is one of the most poignant recent examples of this. That sort of perversion ends up distorting the whole, and I think we are seeing lots of evidence of that. Plus, like New York, the sheer size of Texas alone gives us an outsized influence on federal politics, policy, culture across the country. All right, that's the bad news, but you got to be an optimist to do civil rights work in Texas, and I am, and I wanted to end on a hopeful note. And I'll leave you with a couple of hopeful things. One is, we heard a little bit already about the president's passionate speech yesterday. I was heartened by that, also by some signs that there will be movement in the Senate. I personally believe this next week or two will be pivotal. I'm really looking forward to hearing from other speakers who engaged in that federal work. I'm happy to talk at a later point about what these new laws, the Freedom to Vote Act and the John Lewis Act would mean for Texas. Let me just say it would be transformative, and it would go a very long way to correcting the issues I've highlighted and shoring up our democracy. Also, I'm hopeful because even though reform is not going to be easy, I have seen the power of the growing voting rights movement. And this summer in Texas, against all odds, we had a multiracial, very diverse coalition of business leaders, faith leaders, activists, everyday people show up at the Capitol and testify and rally and call their lawmakers. And while we were not ultimately successful in stopping a new law from going into effect, what was passed, while bad, was mitigated from the original version. And that right there shows you that there is hope. I mean, if this was possible in the state of Texas, it is possible in this incredible country. And so I will leave it at that and know once again that I am so pleased to be here with all of you tonight and looking forward to the discussion that will ensue.
Mimi, thanks so much for that. If I could just ask one follow-up question, just briefly, because we have a lot of speakers, we want to keep moving. But if there was one thing that lawyers who are listening to this could do to help in the fight and in the issues that you just laid out there. Is there one thing that you could tell them that they could do to help folks in Texas?
I'll be such a lawyer and give you two things. I mean, one, federal reform is pivotal. So anything you can do, calling your lawmakers, writing letters to the editor, et cetera, especially in these next couple of weeks. In addition, at TCRP, with national partners, we run a robust election protection campaign. We will do that in 2022, and we are always looking for volunteers, and we can always use out-of-state volunteers.
Thanks so much, Mimi. Next, let's turn to Jerry Vadamala, Director of the Democracy Program for the Asian American Legal Defense and Education Fund. Jerry, you've got the floor.
Thank you, Bridget. It's great to be here. Thank you, the Bar Association, for the opportunity to address everyone. ALDEF, the Asian American Legal Defense and Education Fund, we are a national civil rights organization. We're based in New York, but we do work all across the country. And unfortunately, we've been in Texas a lot recently. We are currently in 2 active litigations there, one involving SB1, where we're working with Texas Civil Rights Project and other organizations to protect voters. We're also working on a redistricting litigation, and this is very timely. Redistricting is happening now all across the country and all the different states and some local jurisdictions. We're also very active in New York. And one thing I always tell folks that attend some of our presentations is that redistricting, in my view, is the most effective voter suppression tool out there. It is the most effective because all of the work that so many advocates do, many groups that we work with in election protection and other matters, on naturalization in the Asian American community with largest share of new immigrants, the fastest growing racial group. So many folks are immigrants and they look to naturalize. So many groups we work with do these naturalization clinics. Once they naturalize, voter registration, a lot of voter registration work, getting out the vote, GOTV, the voter protection work that Mimi mentioned on election day, protecting voters at the polls. ALDEF does a big program on that too. Census, so many people worked on census tirelessly to make sure that everyone was counted. All of that goes out the window if you don't have fair districts. I could speak to this personally. A lot of the work that we did in redistricting around the country, even right here home in New York, you think you have, you're in a blue state, you'd have fair districts, but so many communities, especially communities of color that are protected under the Voting Rights Act, were unfairly divided to numerous different districts. We had a great article in the New York Times that was covered for Richmond Hill South Ozone Park in Queens, a community of Asian American residents that were divided into seven different state assembly districts. It is impossible to elect a candidate of that community's choice. And it's not, oh, great, we have 7 representatives. What happens in that situation is you have 7 representatives that do not need to be accountable to your neighborhood, to your community, to your residents, because you're only a small part of their district and you get passed along and nobody's responsive to you. And it really exacerbates a lot of other issues that the community needs assistance with, right? So not being able to affect the outcome of the election, it's classic vote dilution. And that's one of the protections we have under the Voting Rights Act. Now, the reverse is also true. If you have fair redistricting and you do keep communities of interest whole within individual districts, and in certain places where you have larger districts like state, senate, or congressional, if you combine communities of interest that have similar characteristics, that it makes sense to keep them together in one district, well, then the community can elect a candidate of their choice and participate equally in our democracy. And even in a place like New York City, where you have over 1 million Asian residents, which by themselves would be the 10th largest city in the country, right after Dallas. Well, that community was never able to elect an Asian American to Congress from New York State, despite having these large numbers. Only when we went to court in the last redistricting round, a case called Favorites v. Cuomo, and the court drew the congressional districts and drew a fair district in Queens that was centered in Flushing. There's a large Asian American population, kept the Asian American communities of interest together. Well, several months later, Asian Americans elected the first Asian American to Congress from New York State. It was that quick, that instantaneous. And that's almost at every single level of our government. At the state assembly level, the same situation occurred. Only after fair districts were drawn and we had a state assembly district that kept a community like Flushing, Queens together in one district, well, what do you know? Right away, almost instantly, we had the first Asian American elected to state assembly. Now, we had those issues in New York. As I mentioned, Asian Americans are the fastest growing racial group in the country, and in most states, they are the fastest growing racial group, including in New York and in Texas. Texas is the only state that gained 2 congressional seats in this last reapportionment. 95% of that growth was fueled by people of color. 95%. All those people that are moving to the state, 95% were people of color. Well, the new lines that were proposed by the legislature and passed, they turned those numbers on its head. You don't see the new lines reflecting that growth in communities of color, in particular with Asian American communities in certain places. For example, Fort Bend County, right outside Harris County where Houston is, there's a huge concentration of Asian American residents in a place called Sugar Land, right in Fort Bend County. If you take a heat map, you look at the state, put a racial heat map overlaid, and look at those new lines. What you'll see is where the deepest concentration of Asian American residents are, those areas are sliced and diced, and small pieces of the really concentrated Asian American communities are grouped with rural white voters hundreds of miles away, where they have nothing in common, right? That's classic vote dilution. And what's shocking here is how brazen Texas was in this last round. Texas has been sued successfully in the last 5 redistricting rounds and has lost at least 1 case. What's different here is, as Mimi touched on, we don't have pre-clearance. There's no more Section 5 pre-clearance of the Voting Rights Act in effect. So when things like a new redistricting plan, things like SB 1, the voter suppression law, those things no longer have to be pre-cleared or pre-approved, where the burden used to be on the jurisdiction, Texas, to prove that it would not have a discriminatory impact. Well, now groups like ALDEF, Texas Civil Rights Project, other groups around the country, we are playing whack-a-mole and trying to litigate as many of these cases as we can. And hopefully we'll be successful. We don't know, it's an uphill battle, but we are fighting the good fight. And these things now take a large amount of resources and millions of dollars to litigate these redistricting cases. But we are fighting the good fight in those places and identifying where we think there are violations of the Federal Voting Rights Act. I mentioned Section 5 has been nullified by the Shelby County v. Holder case in 2013, but we still have Section 2 and we have other provisions of the Federal Voting Rights Act that we use every day in our practice. Now, some of the less sexier provisions, if I could say that, beyond Section 2, we have Sections 203 and 208. These are the language access provisions of the Voting Rights Act that at ALDEF, we litigate a lot of cases around the country on those provisions. I want to just touch briefly on some of them because we have filed cases in both New York and in Texas under these provisions. What Section 203 says is that if there are a certain number of people within a certain voting jurisdiction, the number is 10,000 or 5% of a voting jurisdiction, that are citizens, they have to be voting age, which is 18 or over. They have to be limited English proficient, meaning they speak English less than very well. And the rate of illiteracy is higher within that group. Well, then under Section 203, that language group can be covered under Section 203 for a jurisdiction. And if they're covered, what that means is that every single piece of voting material that is in English, it must also be translated into that covered language. So in New York, Chinese covered in Manhattan, Brooklyn, and Queens. Korean is covered in Queens. Asian Indian, including Bengali and now Sikh, is covered in Queens County. And it's a great thing to have that, But through our election protection, we've noticed through the years, jurisdictions don't always comply with that. And we've had to actually sue them to have full compliance. When Chinese was covered, the Board of Elections refused to fully translate the ballot. They refused to, first they said it couldn't fit on the voting machine. Then they said the candidates' names could not be transliterated. And then we had all these problems. We had Mandarin interpreters where you had mostly Cantonese speaking voters and vice versa. And they came back and told us, well, isn't that the same thing? Well, no, it's not, right? We actually had a situation where an actual ballot for a primary election in Brooklyn in 2000 was mistranslated. The Chinese ballot was mistranslated, and Democrat was mistranslated as Republican and Republican as Democrat. All right, so we eventually had to sue the Board of Elections for failing to comply with Section 203 for Chinese and for Korean in 2006. And again, we had to sue the board in 2013 for not providing Bengali ballots in Queens as was required. Only after we sued them did we have full compliance. Unfortunately, in Texas, we also had an issue with Section 208. 208 is much easier to comply with. That's a provision that allows you as a voter, if you cannot see the ballot, if you cannot mark the ballot physically, or if you cannot read the ballot because you're illiterate or because you are limited English proficient, doesn't matter, you can't understand the ballot, you are allowed under the Federal Voting Rights Act to be assisted by any person of your choice, as long as that person is not your employer or your union rep, because they will tell you who to vote for. Now, many Asian American voters that are limited English proficient in a place like Texas, they rely heavily on Section 208. They have somebody come in with them. If you can imagine who that person usually is, it is usually their minor child or their grandchild, many times. Now, unfortunately, Texas had a law on the books that said all interpreters had to be a registered voter in the county in which they provide their service. Minors cannot be registered voters. We litigated this case in 2015. We won at the district court level. We won at the Fifth Circuit. We have a permanent injunction against the state. And then unfortunately, we have SB 1 that can definitely be interpreted as violating that injunction. We are fighting that. That further restricts Section 208. It basically states that if you do anything beyond strictly interpreting that ballot and saying what it says, if they ask you a question like, what do I do with this? Or any other further question, you could be held criminally liable, right? So clearly, in our view, an illegal restriction on what Section 208 is. That's why we're fighting with many of our allies. They are one of the many horrible provisions of SB 1 that we're fighting against there. I want to say this in closing. It has been a real challenge litigating cases post Shelby County. No more pre-clearance. The burden now is on us. It's much harder. And what made it even worse in the last administration, among many other things, was DOJ was completely absent. They did not bring a single voting rights case in the last administration. And the one active case they were involved in, they actually switched their position in a Texas litigation on voter ID. So it was really hard. We were left to ourselves. What's heartening to me, and I'll leave, I guess, on a positive note here, is that DOJ has intervened in both Texas cases. They have intervened in the S1 case. We've seen them involved in the Georgia case, and now in the Texas redistricting case, they've also joined us. So they're welcome addition, and it's nice to finally have the federal government and the Justice Department fulfilling their obligations and duties as was originally intended. So I'll end on that.
Jerry, thank you so much for that. Thank you. I wanted to ask a follow-up question, but I'm really mindful of the time. And I know that we have two professors with us, and Professor Stewart, I know that you have a time constraint. So I'm gonna go a little out of order on our agenda. And we're gonna go next to Professor Charles Stewart III from MIT. He's the Keenan Sahan Distinguished Professor of Political Science, and he's going to talk about election administration. Professor Stewart?
Thanks so much for having me. Thanks, Bridget, for overseeing this august group. And I am, so being out of order, I can't rely on many of my colleagues who've spoken before me, but let me just say a few words that slightly change the emphasis about what's been said so far, but I think it complements it. So I'm probably the one who's unlike the others in this symposium, in that I'm not an attorney. I'm a political scientist. And I don't have a legal degree of any sorts. Attorneys sometimes, especially law faculty, like to have me around. And so I get the joy of talking a lot with law school professors and other lawyers about election administration. I think, you know, the topic of this symposium is, you know, looking at voting rights, looking at the threats of voting rights. I mean, certainly we can see them in Texas. As an aside, I am sitting in a hotel room in San Antonio, although I'm from MIT. So maybe I'm soaking in some of what's going on in Texas. There's a lot of challenges to voting rights right now, and many of the panelists have talked about this, and we'll talk about this in the future. Looking historically, you know, for several decades, more or less, the arc of voting in the United States was to expand voting rights and to expand voting opportunities, and that arc came to a slowdown around, the second Bush administration didn't help. And then certainly the Shelby County decision not only put a stop to that, but also began to reverse things. And so now the question is to people who believe in access to the ballot box, who believe that the biggest challenge to voting in America, in the United States historically, has been attempts to disenfranchise people of color, what to do. And there's one important path, which is to pursue bills like HR 1 on Capitol Hill. There's another path that I've participated in, and many of the people on this call have participated in, and that's litigation. But there's a third path, and that's what I want to talk a little bit about, and that has to do with administering elections. And doing the blocking and tackling of election administration. I like to needle my election law friends oftentimes by just noting that simple litigation will not always get you a free and fair election if the election administrators are not in a position to implement things. And just as an illustration, the reason of that, I mean, the reason I'm in San Antonio is I'm doing what I normally do, which is talk about election data and try to figure out how to make election data speak to the current state of elections. And there are federal laws requiring things under the National Voter Registration Act, which was passed in the 1990s, the UOCAVA Act, the Overseas Voting Act, the MOVE Act, which is another act that has to do with overseas and military voters, civilian and military voters. Civilian and military voters are very, very sympathetic to lawmakers, and yet decades after these laws have been passed, there are many jurisdictions in the United States that are still not implementing them. Money has not been allocated, administrative time has not been paid, and the laws are just not being followed decades later. Now, why is that? It's not because the laws weren't passed. The laws were passed. So now the question is how to get them implemented. And one of the answers is that state and local officials haven't paid attention to supporting the infrastructure, which is our election administration process. And so one of the things I would ask for people to think about in this symposium is, after the laws have been passed and after the litigation has been successfully pursued, what about the people who are left to administer the laws, who need to implement them? And it is, yes, court orders are powerful things, but they are not all powerful, and laws are powerful things, but they are not all powerful. And oftentimes there are administrative challenges that need to be thought about. And so looking ahead, as we look to pushing back a bit against efforts to to narrow the scope of the electorate in the United States and to try to resist the future of America, which is a less white, younger America. What do we need to be looking at? One of the things we need to be looking at is funding elections. In this last election, for instance, despite the fact that it was widely known that we would have to basically double our efforts to administer elections, state and local governments didn't follow through in many places and fund what was needed. And this led to private philanthropy coming up with over $300 million to help pay for basic services at the local level. This is something that I've called bake sale for democracy. Getting, well, people who are concerned about voting rights need to be concerned about appropriations at the state and local levels for poll workers, for equipment, for postage, for finding polling places, for communicating with voters. Yes, what's required under sections 203, but also going beyond that, reaching out to voters, reaching out to new voters, doing the things that need to be done. Election officials, oftentimes even when they're willing, they're not always willing, but often they are, they don't have the wherewithal. And so I would encourage people to advocate to, first of all, find out what's spent on elections in your county or local jurisdiction, and to ask your local official what's needed and to advocate on their behalf for increasing that. Likewise, poll workers, that's still an issue. The nation put in a big effort in 2020 to bring poll workers to work the polls. Well, January 6th and other efforts have made being a poll worker a perilous thing. And we continue for 2022 need to find new poll workers. We need to recruit them, we need to pay them, we need to protect them. So that, and by the way, we need to protect the polling places those poll workers would be in. Because one of the things we know from social science research is that if you move a polling place, if you close a polling place, the people who are served by that polling place are measurably less likely to vote. So recruiting, funding, locating poll workers, critical. Oh, and then critical final thing. We also know that in 2020, communities of color were disproportionately places where polling places were closed and moved. So this is a civil rights issue. This is blocking and tackling, hiring, placing, supporting poll workers, keeping those polling places open. And then finally, there's the issue of increasingly, as we're moving into mail ballots, and it's not so much in Texas, there's been resistance by the government to more mail ballots, but New York is moving to more and more mail ballots. Mail ballots get rejected in places like New York. A lot of them get rejected. And another thing we know is that rejected mail ballots tend to be disproportionately among people of color and young people. And so dealing with communicating with new voters, communicating with communities of color about how to successfully complete a ballot and get it done right is a civil rights issue. And I could go on, but I guess, the point I would want to make is in no way should be interpreted as suggesting that, the other things being talked about here are unimportant. They're very important. But I would also ask people to consider what happens when the advocacy goes home, when the polling place, when the legislation is passed, when the judicial decrees have been made, and people actually have to do things on the streets to get ballots into people's hands and get them counted, because that's the part that makes the vote effective, and that's the thing that we're fighting for. So, thank you.
Thanks, Professor Stewart. And I know that you need to leave soon, so I am going to ask you a follow-up question. And I may pull Jerry's comments into this, in so much as I think what he hit on, particularly in terms of language access, something that we have seen here in New York State and New York City, and your comments about the need for good election administration. We've had here in New York City, our elections administrators, our New York City Board of Elections, actually sue to prevent additional translators at our election sites. And at hearings held by Senator Myrie, we've heard elections administrators from other parts of the state say point blank, don't pass any more changes. You know, we can't keep up with these election reforms. So my question to you is, you know, we talk about wanting to improve election administration. What does your research tell us about the best way to do that? Is it, you know, taking partisanship out of election administration and making it more professional? What are the approaches that we should be thinking about and pushing for?
Thanks for that question. I'll say one thing that might be controversial in this group, and unfortunately I'll make it, and I might have to run away before we can fully address it. But I take it seriously when election officials say, watch what you pass and how fast you pass it. And this gets back to the question of administering elections well. I think it's this is a difficult issue because but what I will say, and what we do know, and we actually know this from research nationwide, is election officials do feel like, and I think it's true from my observation, that they're the last people who are consulted by NGOs, by lobbying groups, by state legislators. They're the last people consulted when election reform is considered. And that involving election officials in putting together reforms in the long run is probably the best way to get those reforms implemented. I think the classic case is Colorado, which has the easiest way of voting in the United States. They mail everybody a ballot. You can return it by mail, but they still have in-person voting if you want to vote in person. They have very high turnout, very high turnout throughout the state. They're getting ballots in the hands of people that never had ballots in their hands before. That effort was led by a combination of county election officials advocating and kind of working out the details with activist groups who wanted to expand access. And so I think that that's the best way to do it. Now, I mean, there's certainly cases where the election officials are the sticks in the mud and need to be resisted. I'm not going to doubt that at all. So it's very, very fact specific. So I would ask to at least consider that. The other thing I would say is there is that buzzword within elections that you will hear in other parts of the country that are not called New York and not called Texas, and that's called voter-centered elections. And so when you talk to election officials and people in places like Colorado, they would talk about voter-centered elections. And I think that that people who are concerned about voter access, that to turn the question into what does it take to make this event about the voters? And I know this is difficult in places like New York State, not to pick on New York, where many of the laws in New York, kind of the fundamental structure of places like New York, were built around how to control party competition in the 1880s and 1890s. Or in Texas, where it's still legacies of Jim Crow define a lot of the fundamental structures. It really requires a sea change of election administration in places like New York and Texas. And so I would ask for folks in both places to be asking just a simple question: what is best for the voters? We understand these other issues, but what is best for the voters? And what is best for the voters is oftentimes in the long run addresses many of these issues, language access, and makes it simpler for election officials, because oftentimes they are doing things for reasons they don't understand or are not issues anymore in their mind.
Thanks, Professor Stewart. I want to go to Professor Richard Pildes from New York University's School of Law, who's going to talk about another piece of federal legislation, the Electoral Count Act.
Thank you very much for inviting me to participate. I'm always pleased to listen to Charles, so I'm glad I had an opportunity to listen to him for a bit. Actually, I'll just pick up on one of the questions that was asked in discussing election administration to point out something many of you probably know, but in most democracies, they actually have independent institutions that do election administration. And so many of the issues that we talk about, so many of the things we worry about, including the things that I want to talk about with you here, stem from the fact that we do not have independent institutions to oversee the election process. We also don't have professional election administration for the most part, which many other democracies also use. This is part of what I think of the somewhat sort of perverse sensibility about democracy in the United States, that we tend to believe we have to have democratic control, direct democratic control over so many aspects of our system. And in some contexts, like overseeing the election process itself or drawing election districts. I think it's a very unhealthy structure, but that's what we have. But it's important sometimes, I think, to remind ourselves that we are unique in this way, and that's why many of the things that we worry about take the shape that they do. My focus recently, and what I want to talk about here, is the risk of what we call election subversion, the concern that the lawful winner of the votes will somehow not end up actually being acknowledged as the winner because of partisan manipulation or corruption of the process at one level or another. And this is a great concern among many Americans in our age of distrust now about the election process. So there's just recently been some data released that 56% of Republicans believe that in Democratic controlled states, the outcome will be manipulated. 67% of Democrats believe that in Republican controlled states, the outcome will be manipulated. And the concern, of course, is particularly heightened when it comes to the presidential election. Let me just tick off a few of the different sources of this risk that we are now very, very concerned about. One has to do with personnel. So in the aftermath of 2020, with all of the pressures, threats to themselves, to family members that many election administrators have been experiencing, we are seeing very significant resignations of experienced election administrators who don't want to have to deal with the culture of distrust and what it means for them. And partly to fill that gap, but also partly because of the vulnerabilities in the process that have been exposed in the aftermath of 2020, we're seeing more partisan activists seeking out these positions, from high-level Secretary of State positions to lower levels of election administration, including people who are running based on their position that the 2020 election was stolen. So there's the personnel problem. There is the restructuring of the election administration process that has taken place in a couple of states so far. There are possibilities of this happening in other states, restructurings that create the risk of more partisan manipulation of that structure. And then third, there's now the concern about direct intervention from political institutions, whether it's state legislatures or Congress, in the context of counting the electoral votes in the presidential election context. In the presidential context, the main statute to focus on here is the Electoral Count Act, which was the law that was designed in the aftermath of our most disputed presidential election to try to create a stable framework for resolving a potentially disputed, closely contested presidential election in Congress. We had not had to worry about this statute basically since it was enacted in 1887 until 2020, when it came to the foreground with the objections to receiving the vote by many Republicans in the House and 8 Republican senators. So this statute is critical to reform, to clarify, to update before we get into the election cycle for the 2024 presidential election. Some of the reforms to it are actually fairly easy and straightforward. They're actually clarifications. I think the law already, with respect to the role of the vice president, for example, is best understood as denying the vice president anything other than a ministerial role when he or she presides at the joint session of Congress when the electoral votes come in. Vice President Pence recognized this and performed his role with great integrity. But that point of pressure or vulnerability has now been exposed. And we need to clarify that the vice president has no role other than a ministerial role. We need to raise the number of objectors who are sufficient in the House and the Senate to actually trigger an objection to the count from a state. Now it's 1 senator, 1 representative. That's way too low. Those are actually fairly straightforward. The much more difficult issues in reforming this statute and the process is thinking about the appropriate relationship between Congress and the states in a culture in which we have good reasons to distrust the institutions at both levels. So we can give Congress significant power to oversee the results, the process in the states, and reject votes if Congress concludes there's been corruption of the process at the state level. But of course, we worry about that power in Congress. So we could deny Congress the ability to look behind the returns from a state, which I think is in fact the best understanding of what the current act actually does. And some people in fact argue that that's what the Constitution requires, that Congress can't look behind the returns from a state. But then of course we worry about corruption of the process at the state level, including state legislatures or these other partisan forces penetrating into the state process and corrupting it. So it's almost a pick your poison kind of situation as we think about how to reform the ECA. And I don't know that there's any way to really squeeze out of the process the risk that whoever has the final sort of decisional authority will abuse that authority for partisan purposes. I'm not confident there's a way to really drive that risk out completely. In my own view, what I'm looking for is what I think of as sort of an intermediate institution between the states and Congress, so that we're not relying on Congress to ensure the states act lawfully, but we're not leaving the process completely to the state level. And I have been thinking about and working with some others on proposals to put the federal courts into a role in which there can be a federal cause of action to ensure that the state certification process complies with federal law, constitutional law, federal statutory law. And I am drawn to that structure in the midst of this great distrust that we have, and for legitimate reasons now have, in both how Congress and how individual states might carry out their roles in the presidential election process. I think Electoral Count Act reform will definitely get on the congressional agenda at some point after the 2 big voting bills are resolved one way or the other in Congress. There actually are some provisions in the Freedom to Vote Act which were retrofitted to deal with this risk a little bit. They were not part of the bill until very late in the day. There are provisions that would make it a federal crime to intimidate officials who are involved in tabulating or canvassing or certifying the vote, protections against intimidation, coercion, and the like. I think those are all good ideas. If the Freedom to Vote Act itself does not end up passing, I would hope those provisions would be pulled out and discussed as part of Electoral Count Act reform. So this will get on the agenda, but because there are difficult issues there, particularly on this issue of Congress and the states and the proper structure there, I don't know if we will get to the point of having enough agreement to actually do more than clarify the easier things that need clarification in the act. But let me stop there. I don't want to intrude on the time of other speakers. So thank you.
Thank you, Professor. One quick follow-up for you. When you talk about getting the Electoral Count Act, when you talk about envisioning the Electoral Count Act on the congressional agenda, but seeing it as something that comes after these other two big federal bills, do you see there being sort of a point by which it needs to happen or it will become too politicized as part of the 2024 cycle?
Yeah, I think the further out we are from the presidential cycle starting, the better the context for deliberation in Congress over this statute. And those of us in the election law area have certainly known for a long time that the statute needs to be addressed. In the last 3-4 weeks, there's been all sorts of signs that this is really moving up on the agenda. There's a bipartisan group that's now discussing this ECA reform. This has been going on quietly in Senator King's office with Senator Klobuchar, kind of on the Democratic side. One thing I want to say about this, by the way, it's extremely important that any Electoral Count Act reform be bipartisan, and not just because there's the filibuster issue. That's the less important reason. Even if you could push it through on getting rid of the filibuster on a party line vote, this act is largely self-enforcing in Congress. And so there has to be buy-in from enough people on both sides for the act to actually perform its function. So if one party were to ram through its version of Electoral Count Act reform, if it could do that, the other side will almost certainly ignore it when the time comes. And so it's particularly important for this statute that whatever emerges through a bipartisan process.
Thank you so much. The conversation so far has really underscored the vital role that our elections administrators play in running free and fair elections. And so I want to turn to two folks who have played an incredibly important role in both New York and in Texas. And since we've talked a lot about New York, I'm going to switch again our agenda a little bit and go to Dana DeBois. I'm going to do this as best I can, Dana. Dana DeBoivier, who is county clerk running elections in Travis County, Texas. And please say it so that I know that how close I came.
You came pretty close. Thank you. It's Dana DeBoivier.
I didn't come close enough. Thank you so much. And I think your story is, which we're about to hear, is incredibly compelling, but also speaks to what Professor Stewart was talking about in terms of people who have the institutional knowledge, the experience, who know how these systems work, who are just making a choice to retire, which I understand you are doing in the next couple of weeks. So with that, I turn it over to you for your story.
All right. What I would like to do is share with you from the practical standpoint, what voter suppression looks like. And I've got some very good examples that come from Senate Bill 1. Senate Bill 1 specifically targeted two counties in Texas, Harris County, which is Houston, and Travis County, which is Austin. And the way we were targeted was in some specific areas. And we're not going to have time for me to talk about all of them. Unfortunately, there was quite the list. But I do want to talk about a couple of pieces that will make it crystal clear exactly how they were intending for voter suppression to work. First of all, let's talk about the ballot by mail provisions. You've heard some comments made about them, but let's talk about exactly what the law calls for. There is an extra ID requirement in Senate Bill 1 for anyone who wants to vote by mail. And in Texas, you have to be qualified to vote by mail. You have to be either over 65, be a person who has a disability, be absent from the county for the entire voting period, or be incarcerated but not yet convicted of a crime. So there are specific groups, and if you're not in one of those groups, then you are not allowed to vote by mail in Texas. So what happens with this badly written language in SB 1, it has added a requirement that says that any voter who wants to vote by mail must now add either their driver's license number or the last 4 digits of their social security number to the application for a ballot by mail. And those one or the other. And one of those numbers must match the number that is already on, presumably, the original application that the voter filed in voter registration when they signed up in their county to register to vote. Well, do you remember what you put on your voter registration card when you first signed up in your county to register to vote? And if you signed up a long time ago, like me, which was in 1979 for Travis County, there wasn't any kind of requirement like that back then. So not only do I not know what is on my voter registration card, I don't know that I was even required to provide anything in many, many years past. So what we are trying to tell voters is, we're not sure what to say to you, so put both numbers on your application card. And then we have yet to hear from the Secretary of State's office, if you're one of those people who doesn't have a number on the magic number on your original voter application card kept by the voter registrar, do they throw your ballot out because you still don't match? Or are you still allowed to move forward because you gave both your numbers, even though you were only required to provide one or the other? We do not have an answer for that. And Senate Bill 1 also asks right now that if the voter messes that up, and that's going to be very easy to do, that there is a website that is supposed to be designed and opened up by the Secretary of State that allows voters to go onto that website and cure any deficiencies in their application. So now we've created another digital divide for voters. So we've confused them. We have a digital divide. And oh, by the way, this website that's supposed to be up hasn't appeared yet. And we are very close to the date for the deadline for approaching for the first applications for ballot by mail. So it's behind schedule. We don't know what to do. The Secretary of State has yet to produce procedures and rules for implementing this badly written law. In other words, this is what voter suppression looks like. Now, in addition to that, we are also, as elections administrators, forbidden now from sending out any kind of mass mailing of applications to voters, say in any of those 4 categories, to tell them, if you would like to vote by mail, here's an application, fill it out and send it back into us, and we will reply back to you. And that provision in the law is so restrictive that you must fill out your application. Remember to include one, or as we're suggesting, both of the magic numbers. But also, not only can we not send out bulk applications any longer, only political parties and candidates can ask for the materials to do that, but you have to ask for those materials from the Secretary of State's office. What do you want to bet there's going to be a shortage of materials? There is also a brand new form this year. So those activist organizations can't use materials that they have stockpiled in the past. You have to use today's brand new form. And if you're one of those people who wants to ask for an application for a ballot by mail, and you want to call your local county clerk's office to request one, in the old days, you could say while you were on the phone, oh yes, and I would also like to ask for an application for my spouse as well. No, not allowed. Your spouse must call back and individually request an application for a ballot by mail. Again, this is what voter suppression actually looks like when you're on the phone with the voter. Make no mistake. Now, you've heard the mention about, in fact, Dr. Pildes mentioned it just a second ago, the concept of partisan disruptors. We used to have poll watchers, and they were the eyes and ears of the people. We loved them. They were welcomed. Most elections operations were happy to have them there because typically they kept things running correctly. The procedures followed correctly. Well, we no longer have, sad to say, poll watchers. Now what we have is a group of partisan disruptors who are hired and put into polling places and counting stations purely to attack the operations and disrupt either the safe haven of the polling place or the efficient operation of the counting station. And that is the piece that opens up my particular story, because those partisan disruptors were sent into my counting station for the presidential election and for the election after that. They came in with the entire intent of disrupting the operation of the polling center, and worse. Because if you remember back in November of 2020, Texas was at stage 5 of the pandemic with no medicine, no vaccine, no hope of anything. And these partisan disruptors' purpose was to take off their masks, stand on top of the workers in these offices, trying to either deliberately infect them with COVID or just leave the impression that that's what they were trying to do. And did it really matter which they were trying to do? The intimidation was still very clear. It went so far that one of these partisan disruptors at the end of the day, when we were working in the counting station, took off her mask that she had actually been wearing for most of the day. And as she was exiting the office, threw the mask in the face on the desk of our election receptionist as she was exiting. And she said to my receptionist, "Here, I've already had COVID. I'm gifting you with my antibodies." These are the people we're now dealing with. Now, the rest of my story about the Attorney General, I'm happy to tell it, but there are a couple of other points that I want to make before we get to that piece of it. We are now in a situation with Senate Bill 1, where this bill has now required every election official in the state of Texas to produce and install and operate video equipment that must stream the entire time any ballot box is open. So not just when we're having voting, but anytime a ballot box is in operation. And that automatic streaming is there to reduce and catch any so-called voter fraud inside the polling place or inside the counting station. That is a creepy big brother kind of thing. But before we go too far down that lane, I decided to embrace it. I decided I love this videotaping of voters, as weird as it is, because I think it's going to backfire on the people who put it there as an intimidation technique. I think it's going to be the best thing that's ever happened to those of us who are trying to control the Karens and all of the other partisan disruptors, because now it's going to be, smile, you're on candid camera, and all of your bad behavior is now available for everybody to see real time. So maybe there is a tiny kernel of good news in all of the bad news about SB 1. So let me just wrap up, and then I do want to come back to what they ended up doing to me for fighting back against these awful people who were interrupting even the workers in election, their right to either the safe haven for voters to vote or the simple right to a safe workplace. What they did to me. What I want to talk about before we go is, what can we do about these unconscionable violations of voters' rights and workers' rights in the conduct of elections? First of all, I think all of the people who are actually conducting elections have to think much more carefully in the future about the messaging to voters. We have to tell voters what it is we want them to do and what we want them to know for the future in ways that are much more involved and much more distinct than we've ever been with them before. We have to tell them to brace themselves for the Karens in the polling place and in Texas, because we now have no permit carry guns inside the polling places. This is our new reality. Now, I think what we have, the way we do that is we start looking at our training classes for judges. You have to require training. Everybody in Texas now requires you to attend a training class. We need to spread that out among as many people as possible. And in those training classes, we need to not only, hone our messaging, but we also have to start teaching de-escalation techniques, just the way they teach them in CIA, FBI, police training classes, to teach people how to start talking down people who are just losing it in the polling place and are becoming a danger to self and others. And one of the most interesting points about the newest theories on de-escalation training is they are beginning to recognize that there are people who are not going to be good at de-escalation training. For example, people like me. I have folks who come at me spitting, screaming, being insane, saying things that are so offensive that I regard them as morally reprehensible. And in de-escalation training, you have to make a personal connection with the person you're trying to work with. There is no way I could make a personal connection with somebody I'm finding morally reprehensible. And so what you have to do is you have to snap to that really fast, and you have to take yourself out of the position and find somebody else to come in. And so what they now teach in de-escalation is to say to the badly behaving person, oh gosh, you know what? Mary or Scott or Pauline or whoever is really good at working on these kinds of issues. Let's call him over and see if he can help you, because he's really good at this. Let's call him over, and then you get somebody in there who can do a better job than you, and you exit yourself out. So I think that's one of the things we have to start thinking about, is better ways to implement de-escalation. We've never done it before. We need to start doing it full-heartedly. I think we also need to start talking to the media and to all of our voters about the golden rule. It sounds small, it sounds silly, but voters will really get that. They understand that they want to be treated in a certain way, and that they have to behave in that same way towards other voters. It's a quick and easy way to get them to comply with normal civil behavior. And then finally, I think we need to start talking among ourselves about what voter involvement in maintaining the safe haven of the polling place, and for that matter, the counting station for the future, is going to look like. I don't want us to get so involved in voters, preaching the golden rule for themselves, that we get into a vigilante kind of situation. I know I could see myself if I were standing in line and I see somebody misbehaving under Senate Bill 1, they're standing on top of perhaps a grandmother who has her grandson who's helping her with a ballot, who's trying to translate Spanish and English for the grandmother, that I would say right across the room, hey, you, back off. That person's entitled to a secret ballot, stop it. That may not be the way we want to teach voters to go for the future, because that may just escalate when in fact what we really need to do is de-escalate. But it might be appropriate for somebody in line watching all this going on to say to the voters next to them in line, hey, do you see what's going on over there? And with a little bit of a group think and a double check on, what it is you're actually seeing, and does it really look like that a group requests the election judge to come over and point it out to the election judge, and then let the election judge handle it. If we could start talking about those kinds of things to teach voters, then I think we have the beginnings of a way to maintain, safety as well as decorum in the polling places. And I'm more than happy to talk to you about what our indicted Attorney General in Texas did to me, as well as to some other people too, to try to stop me from maintaining decorum and prevent the intimidation of election judges, and voters in that particular election. Thank you.
Dana de Beauvoir. Wow. Thank you so much for all of that. And, you know, I know your story. I think there are probably many folks on here who haven't heard it, but would like to hear it. But I am mindful of the time, and I want to actually get straight to Doug Kellner, who is also an election administrator. And, you know, knock on wood, like we have not seen quite that in our New York poll sites. But Doug, you know, when Senator Myrie held hearings across New York State this past summer, there were some pretty shocking stories that we did hear. So is Dana, you know, what she's describing a foreshadowing of what could come to New York, and how do you respond to some of what she laid out?
Well, Dana's my hero, but let me say, Bridget, that the kinds of issues that she's raised are not necessarily unique to Texas. We had a Democratic commissioner in Dutchess County who, in my view, was targeted by the Republican district attorney and the Republican machine that runs Dutchess County, and basically driven out of office on what I thought were ridiculous charges with respect to efforts she made to help absentee voters. And she was forced to eventually do a plea bargain or put up $100,000 worth of legal fees and go to the mat. And Dana, you did a great job by sticking it out, but it is tough when the establishment comes down on you and you have to defend yourself. So that's an issue. In New York, we learned from the 22nd Congressional District contest that there are lots of problems with election administration in New York. Claudia Tenney won that congressional contest by 109 votes in a very thorough and very transparent process of counting those votes. But when you look carefully at that process, you see that there were thousands of voters who were disenfranchised in that congressional contest. And most of that disenfranchisement was the result of poor election administration. With thousands of people whose votes were not counted at all, an outcome with a margin of 109 votes does not give me comfort that our system is working to determine who should have properly been elected to that office. In New York, I guess following up on Professor Stewart's comments, which I very much appreciate and support, we have had major changes in election administration in the last 2 years. We've enacted early voting, implemented electronic poll books, massively expanded the number of absentee voters, not more because of the COVID epidemic than an intentional effort to extend absentee voting. And we're in the process of implementing public campaign finance for legislative elections. The task of implementing the public campaign finance was given to the State Board of Elections, which I think is a good idea. but it will quintuple the number of staff at the State Board of Elections, which has been historically a relatively small agency supervising the counties. And now we will have to add on a large number of people necessary to properly administrate a public campaign finance program. What the 22nd Congressional District contest showed is that in many counties, the level of election administration is very weak, that the county boards of elections are understaffed and their county governments have not given them sufficient resources to do all of the new tasks that have been assigned to them. So that's an issue. With the expansion of early voting, we came to see in a couple of locations in the state where the establishment has used that as an opportunity to take advantage by the location of early voting sites in favorable locations. And Rensselaer County actually was the locus for litigation that found that their process of assigning early voting sites outside of the main urban center located in Troy was arbitrary and capricious. I know Senator Myrie is working on legislation to try to address those kinds of problems. New York City is another example where they refuse to take the necessary steps to implement early voting in a way that would be most convenient for the voter. The state law says that early voting, that a voter should be allowed to go to any early voting poll site in their county, unless it's impossible for the county to implement that mandate. And New York City has seized on that as an excuse for not providing for vote center early voting, even though they could do it if they would take some modest steps to implement it. And I'm hoping that somebody will eventually bring a lawsuit to force them to do that. I am unable to get bipartisan support at the state board to do that, which is generally the case for almost any enforcement action, that the Republicans at the state board feel that the county should be left to themselves and that the state board should provide guidance and assistance, but not be involved in active enforcement. So those are some thoughts on what's going on in New York, and I really appreciate everybody else's insight.
Thank you, Doug. I'm going to keep things moving so that we can get to our discussion. And I'd like to go next to Jorge Vasquez, who is the founding partner of Vasquez Segarra, his own firm. Jorge, the floor is yours.
Thank you, Bridget. It's a pleasure to be here with everyone. I'll keep it simple so that way I don't hold us back from our discussion. I think to Professor Stewart's point, when we're thinking about poll watchers, when we're thinking about how elections run, we need to start thinking about how we want our democracy to be overall. And I start with the premise that democracy is a learned experience. And it's a learned experience whether you're in New York or whether you're in Texas and everywhere in between. And having said that, we need to consider the effect that some of these legislations are going to have on generations to come. And how are they impacting, let's say, a bilingual child who's translating for a parent when their parent is trying to participate in our government and needs assistance, and they're telling that child no, notwithstanding that you, child, are a future voter, notwithstanding that we're not providing you with the services that are basic and fundamental to ensure that everyone has access to the ballot, we're not going to let this person vote. How does that sit with that child, and how does that impact that child 10, 15 years later when that child might be an eligible voter? I think many of the things that we've discussed today are really about voter protection and how can we ensure that people have access to the ballot. One of the ways and one of the things that we haven't discussed yet is that many of the things that go wrong on election day or during early voting are preventable. And they're preventable if folks are speaking with individuals like Commissioner Debevoise. And the way you do that is you want to figure out, well, where are the election sites going to be? Are there going to be drop-off boxes? Where are these drop-off boxes going to be? Are there enough poll workers? What's going on here? What's going on there? And one of the pending legislations that would address this on the federal level and provide funding for states on a local level is the Freedom to Vote Act. And the Freedom to Vote Act not only addresses that, but also touches on something that Jerry mentioned earlier also with redistricting. As we all know, New York is scheduled or is losing a congressional district by 89 votes. Senator Myrie will attest, it makes no sense that 89 individuals are impacting 700,000 people that need representation. One thing that the Freedom to Vote Act proposes is ending prison gerrymandering. I can't say with certainty that there's at least 89 people housed when the census was taken on April 1st of 2021 in New Jersey or in neighboring state Connecticut. But I think it's fair to say between those two states, it's likely that we would have found 89 individuals who would be coming back to New York post-incarceration and likely to come back to New York post-incarceration in less than 10 years, which the redistricting period is good for 10 years. So if we had something in place that ended prison gerrymandering, then New York would likely still have the amount of congressional districts it had prior to the count of the 2020 census. In addition, one of the things that the Freedom to Vote Act addresses is rights restoration. And when I define rights restoration, as does the legislation, it defines it as those individuals who are post-incarceration or custodial sentence. So if someone's on parole or probation, or might have a fine or a fee that they have to pay or restitution that they have to pay, they're still able to be part of the democracy. And rightfully so, in that legislatures are deciding whether these individuals could participate in certain industries without taking into account the impact that disbarring or disqualifying someone has. When we look at states like Texas, when we look at New York's former practices, when we look at places like Florida, what we see with rights restoration is that many individuals who are convicted of a crime return back to their communities. And if these individuals are returning back to these communities, and many of these communities are over-policed, and there are constitutional issues there that happen, as we're all aware, in New York City, for example, with stop and frisk, we could pinpoint 4 to 6 different neighborhoods. When individuals reintegrate into society and move back into these communities, and you don't allow these individuals to participate in our democracy, you're essentially muting countless individuals from participating in our basic ability to hold people accountable, namely elected officials. So I would urge folks not only to call their senators, not only to call their local and state elected officials to rile up Congress and asks Congress to pass the Freedom to Vote Act as well as the John Lewis Voting Rights Advancement Act. One act is about the administration of elections, which is the Freedom to Vote Act. The other bill, the John Lewis Voting Rights Advancement Act, touches on the protections of pre-clearance and things that Jerry hinted at. When we look at the last, let's say 20 years, there's been so many different rollbacks on how individuals who are not Caucasian or considered minority voters are impacted by these Supreme Court cases, whether it's pre-clearance or whether it's something else, right? Whether it's an ID law. When we look at what goes on in Texas and how it impacts New York, we know that the first thing that comes out of the senator from Texas' mouth is always New York. Whether someone from New York is testifying before this senator or not, he always wants to make the comparison, but we have this, and in New York, we don't have. And in New York, they don't have that. Also, Texas tends to make the news. Similarly, Georgia, Florida also make the news. So when we look at SB 1 in Texas, we have to consider SB 90 in Florida, SB 202 in Georgia, because that's what voters in New York are hearing and seeing. And when they hear and see that, they're not necessarily thinking this is only happening in one state. They think that that is the entire system. And having a view like that impacts individuals' will to participate in elections, as well as in how they think the system works or should work. So to tie up everything that we've said so far, we certainly need a federal push to pass the Freedom to Vote Act, as well as the John Lewis Voting Rights Advancement Act. And I agree with Professor Stewart and I think Professor, what Richard said, that litigation isn't the answer to everything. And Jerry hinted at that litigation is very expensive, which is why I commend Senator Myrie for proposing legislation that would provide groups, attorneys alike, with attorney fees just for addressing something prior to litigation. Litigation isn't the end all be all, but sometimes we need to make sure that we're using whatever tools are available. And I think that New York is making tremendous strides. And I'm happy that the City Bar Association is having this virtual panel today, because it's important to hear from others outside of New York, just like it's important for individuals at the White House and in Congress to hear from folks outside of the Beltway. The Beltway being Washington, D.C., Virginia, and Maryland. And the way we do that is we might want to show up to the White House. There's many actions every Thursday happening that's led by the League of Women Voters and People for the American Way. And there are individuals who are protesting regularly and risking arrest to show the Biden-Harris administration that voting rights are crucial. And it's great that the president is mentioning voting rights now. It's great that he's understanding that if you want a robust economy, then you need a stronger democracy. You cannot have a robust economy without a strong democracy. And I'll leave it there.
Thank you so much, Jorge. I want to get to our elected representatives who, among this group, have the most power to make some changes to how we run these elections and to protect voting rights. And let's start with State Representative Jessica Gonzalez. She's Vice Chair of the Texas House of Representatives Committee on Elections.
Hi, thank you for having me here this evening. So I have the honor of serving as the Vice Chair of the Texas House Elections Committee. But aside from my legislative portfolio and working on elections issues, I had previously clerked at the voting rights section at the DOJ during the Obama administration and served as voter protection director for his re-election campaign in Nevada. So I know a little bit about what discrimination looks like when it comes to the elections process. Unfortunately, as we've heard from some of the other folks from Texas, as you know, we've seen, towards the end of 2020 and throughout 2021, Republican lawmakers, they've pushed for policies that would restrict the right to vote for millions of eligible US voters. In Texas, every session, we've seen attempts to suppress the vote. We've seen an omnibus elections bill being filed. It's never actually passed until this past session. And Dana, she mentioned about being punished for speaking out, and the same thing happened with us. Those of us, myself included, obviously, when we did speak out, it just, we had folks that would testify, and people with disabilities, senior citizens, a whole host of folks that talked about how this bill would affect them. It went to deaf ears. But what's been made pretty clear in this discussion is that we've had a long battle here in Texas. Democrats in the House, we use every tool granted to us to bring light to these provisions in this voter suppression bill, in an attempt to delay and hopefully kill them before they get passed. But the Republican chairman of the House Elections Committee, he was determined to do whatever it took to get this bill passed, and even to deviating from standard parliamentary procedures, silencing Democrat folks on the committee, and just being silent in just the entire legislative process. Not only myself and my other colleagues on the committee, but even just on the House floor when asking questions, when trying to be recognized, trying to offer amendments or what have you. But and that Republican chair, I should add, was appointed to, in my opinion, to his position due to his actions to help the former president overturn the free and fair election in Pennsylvania. And so when Democrats were silenced out of the conference committee process, I was not appointed to the conference committee. I wasn't expecting to, but even the Democrats that were appointed to the conference committee were getting drafts of the bill in the middle of the night, right? We would get a new version. It was always just constantly, well, this isn't the last version. There's a version that we're currently working on. And the bill initially went from 23 pages to 67 pages overnight. I mean, this is just how they were, trying to just add provisions in there in the middle of the night. Like some that were added were provisions to change the hours that you can vote on Sundays, which would ultimately affect social the polls efforts, right? Another provision that was added in there that would make overturning elections easier without even having to show evidence of fraud. And so for many of us, I think for I would say for the most part, almost every single Democrat, that's where we drew the line. And ultimately we united, our party or our caucus united to try to stop SB1 in its tracks. And I forget what the number was back then, the one that ultimately passed SB1, but we made the historic decision to break quorum the night right before the clock was about to run on being able to pass bills through the House, and second to the last day of our regular session. And so when we returned for that first special session thereafter, I forget how, I think the governor called us back a couple of weeks later. Then again, it was the same thing. Democratic voices remained silenced. We were forced to break quorum once again. And this time we left Texas and we flew to DC. And during our time in DC, we brought Texas to the forefront on the national media. We met with the vice president. We met with her twice. I was part of the first group that also met with her, as well as congressional members to discuss what was happening here. And unfortunately, SB1 still ended up passing during our second session, special session. But one thing I think was made clear is that Republicans saw what methods minority used to vote in the 2020 presidential election. And yes, it was targeted. It was targeted towards certain counties like Harris County, for example, to limit, the efforts that they made during a global pandemic to try to assure that people were able to vote. And so it was this, attacks on that. Some of the language in the bill was directly aimed at the efforts that they made in Harris County. But ultimately it was crafted to aim at making sure that minority voters would be affected. And many of us on the panel know that just because legislation is not on its face discriminatory, in effect, if it is, then that's what's considered to be discriminatory, and that is what the DOJ looked at when they're looking when we did have Section 5, and I reviewed some of those requests or from Texas as well, and and just because that formula is old doesn't mean that that there still aren't bad actors out there, because there are, and we saw that this session. We saw it when the Shelby County decision came down, and that's when we ended up passing the voter ID law here. But amongst some of the there, and I won't go to the provisions because I know some of my fellow panelists here have gone into some of the most egregious portions of it. But I think one of the big concerns is that county elections officials are worried about securing, even just getting volunteers, getting poll to workers, and Dana can attest to that. And SB1 puts new enhanced penalties on elections workers, while giving partisan poll watchers more power to intimidate workers and voters, when your right to vote is a constitutional right, and your right to be an untrained partisan poll watcher is not a right under our Constitution. It's not a right, and so for them to be giving more deference to these untrained partisan poll watchers it's kind of ridiculous. We want to make sure that our process functions, and every county is different, and so we have to leave that to our administrators, to our county elections folks, to be able to do what they need to do to make sure that the process is smooth and secure, and that people have access to the ballot box. But right now in Texas, we're dealing with this bill, right? And I think that, or this new law, and I think a lot of the problems is that elections administrators don't know what they're going to do. There is current litigation. We're all hoping that the John Lewis Voting Rights Act gets passed and we can reinstate Section 5. I think that if anything, that's one of the most important portions of the bill, or that bill, is because that's going to be one of the things that really saves Texas. Otherwise, it's very scary for us what's going to happen. Just in carrying out the elections this next cycle, what's going to happen to our state. Aside from this voter suppression bill passing, and we've had a historic, it was about 10 months that we were basically in session, and we saw legislation that was being passed that is overwhelmingly opposed by the people of Texas. But it's all just plain politics, and it's pandering to a very small portion of the electorate. But we're seeing things here in Texas, and I'll try to keep it short because I know time is of the essence here. But now we saw that the governor, and he did this before. I think Mimi had mentioned the voter purge that was that eliminated a bunch of people that turned out to be actually citizens, right? And how they put that list together or how they made that determination, it's unclear. But that previous Secretary of State was appointed during the time that we were not in session, right? And so they weren't able to get sworn or get voted on by the Senate. And he did the same thing this time, right? The previous Secretary of State had their office said in committee when I asked the question, isn't our election process here safe and secure, right? And the Secretary of State's office said yes. And so despite them saying that there are no issues, there's no evidence of widespread voter fraud, they would still, they were still moving forward. But so then he ended up stepping down, and then so there was another person, then it was vacant. But it's just kind of going around the process, right? And when you deviate from these normal procedures, that has to make you question what their motive is, and we know what their motive is. And now this new Secretary of State, who was appointed shortly after it being vacant for several months. So the governor had the opportunity to appoint someone when we were still in session and go through the normal process. And mind you, this new Secretary of State was a counsel of record for the lawsuit that was attempted to overturn, the election. And so that just kind of raises some red flags, and we have these forensic audits that are going on here, and especially in counties like mine, districts like mine, that it's about 75% Latino. It affects people in my district. It affects Texas as a whole, because we see how diverse our state is, and Texas is a prime example of the historical discrimination that has happened. Right, that was the reason that the Voting Rights Act passed, and so I won't go into too many of the details of as far as the purging voters. We're seeing that again. What kind of formula they're using, how they're making a determination of who they're questioning, and we've already seen that happen again. That they're flagging voter registration. They're flagging folks who are registered to vote. It turns out that a certain percentage of them are naturalized citizens, right? And so it's trying to knock people off of our voting rolls, right? And we really don't know what the process is or how they're choosing these people. And so, I would really like to have an opportunity to ask questions of this new Secretary of State, and see how he envisions, right? Or just ask questions, because I think that a lot of us want to know what's going on. But again, it's a challenge. We won't stop fighting. But again, it's despite having actual data and having these civil rights organizations, MALDEF, Texas Civil Rights Project, NAACP is are among some of them that testify, and it's and it really discourages people. And my hope is that I think one of the panelists mentioned this, is that we don't want voters to feel that if this is all just fraud, or my vote doesn't matter anyway, we don't want to discourage them from going out to vote, or that they're too scared because they're afraid they're going to commit a crime, or or people are going to be afraid to be a poll worker or elections worker, because they're afraid that they don't understand the law well enough and they're going to get popped with a felony. And so I just I'm a little worried, and I'm sure that a lot of the EAs in several counties across the state are going to have to figure out what we're going to do. But and hoping that Congress ultimately passes something. But I'll stop there and
thank you. Thank you so much. I appreciate both your patience, and I want to just give a heads up to our audience that we were scheduled to go to 8. We're going to go a few minutes longer because we've had such fantastic presenters offer such important and instructive conversation. I want to turn to State Senator Myrie, Zelnor Myrie, who chairs the Senate Election Law Committee. Voter purges, what brings New York and Texas together. Senator Myrie, can you talk about the work that your committee is doing?
So firstly, thank you. I know that the hour is late, so I'm going to be very short, and I'm hoping to encourage folks to address any additional concerns by way of discussion. I think we'd be remiss if we did not contextualize the moment that we're in this country's history. The restricting of the franchise has always happened as a response to the expansion of the franchise for Black and brown people in this country. And that goes back to the founding. We have all been alarmed by the 1-year anniversary of the insurrection, but in 1898, there were white people that stormed North Carolina City Hall. They lynched and killed and dragged Black people in that town. They held elected officials at gunpoint and forced them to resign. And then they ran in elections afterwards and won and stayed. And so violence is a means to achieve power when you can't do so at the ballot box is not anything new in this country. We saw that post-Reconstruction. We saw that we passed the Voting Rights Act, the federal version, in 1964, and saw the largest expansion of participation by Black and brown people in this country. And we even elected a Black president in 2008. And to me, it is no coincidence that the fall of the strongest civil rights legislation in our country's history happened during the presidency of our nation's first Black president. And we have, of course, seen the reaction at post-election of Donald Trump and then his subsequent defeat and what we are now in the moment of, which is a serious backlash against the expanded electorate of Black and brown people in this country. So my hope is that we don't lose that thread in this conversation and that we remember the unfortunate history and context that we face as a country. My goal as elections chair in New York has been to take us from worst to first. And we have done a lot of things in that regard. We've changed almost 80 election laws, but there's still a lot room for us to improve. I appreciated the comments on the administration of our elections, as has been mentioned by some of the panelists. We went all throughout the state. We produced a 50-page report on recommendations to help make the administration of our elections more efficient, to upstand the credibility and integrity of it. And I look forward to having that discussion with my colleagues on how we can get some of that into law this legislative session. And I'll just say that my hope and prayer, I think even during this panel, Schumer announced that he's going to be utilizing some of the tools in the Senate and the Congress to force the vote on voting rights. I'm excited at that prospect. I wish them very well. I hope they get it done. But if they do not, the states stand ready to step in the gap. We have our own John R. Lewis Voting Rights Act of New York here, where I think that we could really advance the strongest voting rights legislation in the country on the state level. And so we are prepared to do that. Governor Hochul, in her State of the State last week, expressed support for this legislation. And so I'm hoping that we can have a meeting of the minds and get this across the finish line. And let me just end by saying that to my friends in Texas, Jessica and Dana, you truly are our heroes. Thank you for standing in the gap. Thank you for being committed to our democracy in the face of all of the things that you mentioned, truly harrowing stories and circumstances. But we appreciate that you have not relented, that you continue to fight. Please know that you have allies here in the state of New York. Some of the things, as has been mentioned, is not unique to Texas. In my home county in Brooklyn, there were thousands of voters that were purged in 2016. We are just now passing legislation to make it easier to count absentee ballots, easier to cure defects. I had to debate a Republican on the floor of the Senate just this week about the opening up of our absentee ballot process and ensuring that if the voter's intent is clear, that vote will count. And so you have friends, you have allies up here in New York. And again, just very grateful to be a part of this panel.
Thank you very much, Senator Myrie, and thanks for your speedy version of what I'm sure was a longer presentation. I want to throw a question out to all the panelists, whoever wants to go, jump right in. I have found that in the recent debate over some of the federal legislation, there has been a push among some thought leaders to reframe the conversation around really focusing on election administration as opposed to voting rights, with some people saying that voting rights, that language has become too politicized. I'm wondering what folks think of that, if you agree with that or disagree, and why.
Please offer just a quick comment about that. I think we need to be very careful about how we talk about election administration, because in our country, it's either been an elected official who conducts elections kind of as a side gig, or we have appointed officials who have very small boards, and the appointed official typically has a very limited area or arena of independence. And so what happens is that we've only got these two models to choose from. The elected official model does bring the partisanship into it, but you also have somebody who can, in fact, stand up and fight back. With the appointed officials, you still have every bit of the partisanship involved, but you have a person who can be fired by 5 people at any point of any day of their lives. And so they are very much censored and cannot speak back, and are the least powerful of these officials, defending what I believe is the right way to approach this, by saying what's best for voters. I'll leave it at that.
Bridget, I'll just say real quick, this is Larry from the Brennan Center, and we've done a lot of work on the Freedom to Vote Act and pushing for the Freedom to Vote Act. I think that's a false choice. When you're talking about, it's the problem that we're facing right now, and I totally agree with Senator. A history in the U.S. of back and forth on granting rights and then pushing back, but we really are at a unique, perilous moment right now. The Brennan Center has been tracking voter restrictions for over a decade, and just this last year, we've seen a 1/3 of all voter restrictions that have passed in the last decade happened in the last year, and this is related to the threats in election administration as well. It's all part of a campaign, the big lie, that the 2020 election results couldn't be trusted, that election administration can't be trusted. And at the end of the day, if we're going to really tackle this problem, what we need is clear rules about when people can vote, how they can vote, and when votes will be counted. And there needs to be a way to enforce those rules. And the way to do that is to pass something like the Freedom to Vote Act, the Voting Rights Advancement Act. And if those 2 things are passed, even if you have this threat of election sabotage, I'll call it sabotage, not subversion, you're going to have clear rules and a remedy. And at the end of the day, that's what we need.
The only addition that I have is that the Freedom to Vote Act doesn't mention voting rights, yet we couldn't even get a vote on the floor when it was introduced. In fact, as the last 2 years I've spent in DC advocating for voting rights and election rights and voter protection stuff. And what I saw is that when you try to go across the aisle to individuals from Republican states, often what was told was, either they haven't read the legislation or they just weren't willing to discuss things with individuals. So for an elected official to have the position that they don't want to even discuss something, and that something has to do with why they're in office, how they get into office, and the fact that they all took an oath to uphold the Constitution, which most state constitutions provide access to those residents of that state, says a lot. So to point on what Lawrence just noted, I think it's a myth that if it says voting rights in it, then it's a non-starter, or that's what's delaying things. The reality is we now live in a time where if you do a soundbite and that soundbite sounds good and it sounds aligned with whatever your party lines are, that's what folks are going to do instead of working on bipartisan legislation. And the reality is the Freedom to Vote Act, similar to the John Lewis, the Voting Rights Advancement Act, neither one is perfect. And there's a lot that was compromised by advocates and allies. And it's really just a piece of legislation that provides basic support for our electoral system as well as for our citizens to have access to the ballot.
Jorge, thank you for that. I wanted to ask, I know Mimi, you need to, you're going soon, and I just wanted to ask you one question while you were still with us. You had talked about some of the things that you are working on and fighting in Texas are things that erode the very sort of foundations of our democracy, and you invoked your daughters and talking about what they would learn, which echoed to me what I heard from Jorge talking about how democracy is a learned experience. And so I'm wondering, how do we teach young people, and how do you teach perhaps your daughters about democracy, given the situation that Dana described in, poll settings that sound increasingly volatile, and possibly dangerous?
Whew, that's a hard one. I mean, I'll say, I have actually taken both of my daughters, I mean, I guess before COVID, but since they were very, very young, to political rallies and events. Dana's nodding. I know she's seen me at some of them, protests of all kind. And I will say this summer around the SB1 bill, there were really moving rallies outside the state capitol. And as Representative Gonzalez said, I mean, people from all over the state and all walks of life, but at some of them, there were people who showed up in paramilitary gear. And, it's pretty scary. And I really asked myself, whether it was responsible as a parent to take my children to that environment, which that right there is an erosion of our democracy. I mean, it was, people, I know I wasn't the only person thinking that it was scary and dangerous to go speak out about our constitutional rights. And I also think that, it's the fear, the confusion, quite frankly, this message from the government that you or someone that looks like you, some of the points that have been made, are not wanted at the polls. All of that is really dangerous. And it is, quite frankly, very hard to combat. I think some of the best things that we've been able to do, honestly, are creating a broad-based movement. And, I was really proud. We had people at the Capitol this summer. I know a woman who was, clutching some of TCRP's materials there to testify, nervous on behalf of one of her kids, who's a person with a disability who would be treated like a second-class citizen under the bill. And I think that is the only way we can restore faith in democracy, is give people the tools, make it as safe as possible. Something we say at TCRP is we are lawyers for the people, that we want to use the power of the law for communities that have historically not had that power on their side. So, all of that together, I think, is the best thing that we can do. And, I agree with some earlier comments that obviously lawsuits are not everything, but at TCRP, for instance, we are bringing a lawsuit under the Ku Klux Klan Act against some perpetrators of political violence. And we are going to continue to do whatever we can to hold people accountable to try to deter that sort of behavior in the future. So, unfortunately, I don't think there's no one thing that we can do, but I do think all of this is being watched by future generations, and that we have to be very active and vigilant right now in our democracy.
Mimi, thank you so much for that. I want to go back to you, Dana. We have, for those of us who, for those who have not heard your story about your fight with the Attorney General, could you tell us what you've gone through in recent months, and how you stood up for voters?
Thank you. I'm happy to share the story. What happened was I told you part of it about the mistreatment of the workers and employees who were trying to work in the counting station. And I was trying to defend them against being infected from COVID. And it was a knockdown, drag out fight. I put my foot down and said, you cannot get more than 6 feet close to these people, and you have to wear a mask. And they were all determined that they would stand on top of these people without masks and breathe on them. And so it wasn't pretty. Ultimately, and I got sued. And ultimately, we worked out an agreement where the county attorneys, not my personal attorney, county attorneys came up with an agreement with the Republican Party that they should do all the things they were supposed to do in the first place, which was wear a mask and maintain 6 feet distance unless they wanted to see something that was right there, where the person was, and then they could walk up to the person, stand next to them for a few minutes, and then back off 6 feet. And what the agreement called for protection for the employees was absolutely nothing. So given those circumstances, which I was completely livid over, I dressed my people in full hazard suits. It was the only way to protect them. Now, given that loss in that circumstance, because I consider that lawsuit a complete loss for all employees who are trying to volunteer and do good things for democracy, working in a counting station. But the next thing that happened was that the Attorney General indicated that that he was shopping around the counties around Travis County to find a grand jury to indict me on criminal charges. The number of charges was unclear, but whether it was going to be felony or misdemeanor was unclear. But what was clear was that they were going after me and that I needed to hire attorneys fast. And I needed 2 attorneys, one for election law purposes and one for criminal defense purposes. And that the criminal defense attorney had to take the lead on the case because that was the more critical part of it. And both were very well known. You would know their names if I told you. Chad Dunn was my election defense attorney. Everybody probably knows Chad. So I was lucky to have them. That was $75,000 to me in their legal fees right off the bat, and they were kind in their fees to me. It was months of constant haggling with the Attorney General's office. And in fact, he did shop it around and took his case without the benefit of a district attorney. He took it individually did it himself, which has just been declared by the Court of Criminal Appeals to be unconstitutional. He took it directly to a grand jury himself and lost. That grand jury in that neighboring county decided that, in fact, I was to be no billed, and I would hope that what they saw was, in fact, that this was a case of projection, that in fact I was the one who was being suppressed, not the other way around, that I did nothing to harm any of their so-called poll watchers at all. And that decision came down on April the 19th after it was filed somewhere in the very early weeks of 2021. However, I did not find out about it because it was not handled through proper channels, through a DA and through the district clerk, until the middle of July. So I did not find out that I, in fact, had been no billed until months later. And I did not find out until a couple of months after that, because I was no billed, I was then qualified under the risk management insurance policy in my county, that county government could reimburse me for the $75,000 in legal fees that I had been out. So ultimately, I did, not have to pay money. And ultimately I was no billed. So it came out as in a very positive way for me. But standing up and fighting back against them was in a climate where he was trying to intimidate me and trying to financially bankrupt me because I stood up to their unconscionable, attempt to intimidate the workers in the counting station.
It is a shocking and traumatizing story.
If you'll excuse me, I forgot to add one more thing. I was not allowed to speak about this at all while it was going on. So on top of being falsely accused, I was also censored. It was the most alone I had ever felt in my entire life.
I'm so sorry. And thank you so much for sharing that story. It certainly highlights what a challenge it is for people to enter into this field and do this work, what would you say to your successor and to people who are going to be carrying this torch forward, since you are preparing to step down from your role?
Right. I did not step down because of this. I stepped down for some other personal reasons. Ken Paxton is not going to chase me out of town. The woman who is running, the front runner who is running to take over my office, has more spine than I have. She will be fantastic. And so I'm very much looking forward to her. And the team that I've set up here in the office to take over just in the few months at the end of this term will also be very strong, and they will be able to stand up for voters, because I do think the voter approach to elections is the correct one. So I think it's all going to be fine. And what I would like to continue doing after the end of this month is I want to continue working on elections. I can be a volunteer. I want to work with Larry. I want to work with a bunch of other folks who deeply care and are just as frightened as I am about this critical juncture in our democracy. I'm scared we're about to lose our democracy. I'm worried to death about it. And thank you for allowing me to take these last few minutes to share this story. In trying to take care of my mental health, as Madam President of the New York Bar had suggested as we began, I was reading Jane Goodall's book, Hope. And in the book, she tells a story about the difference between the optimist and the pessimist in today's world. And I will share that quick little story with you. The optimist is the one who looks around and says, what we've got here is pretty darn good. I'm not sure that we can do all that much better. We're doing really very well. And the pessimist looks at the optimists and fears that they're correct.
Bridget, I wanted to say something to build on Dana's comments. A lot of people had a lot of good suggestions for because this is very frustrating conversations, I'm sure, for a lot of people, what people can do. One thing that people can do is thank election officials like Dana. I was just down with some election officials in North Carolina, and they were talking about how much it meant to them to hear from their constituents. And I think, we often don't think about the people who are sacrificing so much to make sure that our elections run smoothly and that we can vote. And so thanking them, and like many others, Dana's office is an elected office. Most election officials, not in New York State, but most election officials run for office and making campaign contributions to not just in your state, but around the country. Election officials who are committed to nonpartisan administration, to voting rights. That's another thing that we can all do.
Larry, thank you so much for that. We have, Catherine, do you want to give me a time cue here? Because I know that we've run over, but I'm not sure how much. I know this group could continue talking, but I'm also mindful of everyone's time. And so I guess let me open it up and see if anybody has any final comments or, I thought it was really wonderful that Sheila Boston talked about how this was the bar of hope. So given how heavy and hard and how much work there is for everyone to do, if there's anyone who wants to make any final comments about hope for the work ahead.
Well, I'll just say that this is a participation contact sport. And that means that we don't leave things up to chance, and that this isn't beyond our reach. We can do it. We actually have the power to do it. Those who oppose democracy, those who are expending every resource they have to destroy what has been built in this country, can be opposed by those of us who believe in our democracy and who believe that we should not be ceding ground to those who wish to destroy us. And so I am hopeful. I know that this is a despondent time and that there's so much going on. And I think, we have a once in a century pandemic that influences everything that we do. There's so much happening, but I am hopeful because this country's not perfect, but we've done this before. After every time they've tried to restrict, we have fought back. And when I say we, it has been the people that have done this, and we've been victorious. And so this is your moment. This is your textbook moment. There's going to be 50 years from now, 100 years from now, hopefully, if we battle climate change, where people will look back and say, what did you do when our democracy was at stake? All of us on this call, I hope, are going to be able to say that we fought back and we were victorious. So we can do it, and I'm hopeful.
Thank you, Senator Myrie. Is he the only one who has hope?
I think he said it all.
That's a hazard of the job, that you got to be hopeful.
Wonderful. Well, thank you so much. I want to thank the New York City Bar Association. I want to thank this incredible panel of experts. We were moving along in the beginning, and so I didn't get to give my warning, which is, as a reporter, now that I've met you, I'll definitely be calling you. I can't wait to talk again. Thank you so much for your expertise, for your work, and I look forward to talking more in the future.
Thank you so much, Bridget, and thank you to the wonderful participants. And thank you, audience, for staying with us and for doing all you can do. Thank you so much. Good night.
Thank you very much, Senator Myrie, and thanks for your speedy version of what I'm sure was a longer presentation. I want to throw a question out to all the panelists, whoever wants to go, jump right in. I have found that in the recent debate over some of the federal legislation, there has been a push among some thought leaders to reframe the conversation around really focusing on election administration as opposed to voting rights, with some people saying that voting rights, that language has become too politicized. I'm wondering what folks think of that, if you agree with that or disagree, and why.
Please offer just a quick comment about that. I think we need to be very careful about how we talk about election administration, because in our country, it's either been an elected official who conducts elections kind of as a side gig, or we have appointed officials who have very small boards, and the appointed official typically has a very limited area or arena of independence. And so what happens is that we've only got these two models to choose from. The elected official model does bring the partisanship into it, but you also have somebody who can, in fact, stand up and fight back. With the appointed officials, you still have every bit of the partisanship involved, but you have a person who can be fired by 5 people at any point of any day of their lives. And so they are very much censored and cannot speak back, and are the least powerful of these officials, defending what I believe is the right way to approach this, by saying what's best for voters. I'll leave it at that.
Bridget, I'll just say real quick, this is Larry from the Brennan Center, and we've done a lot of work on the Freedom to Vote Act and pushing for the Freedom to Vote Act. I think that's a false choice. When you're talking about, it's the problem that we're facing right now, and I totally agree with Senator. A history in the U.S. of back and forth on granting rights and then pushing back, but we really are at a unique, perilous moment right now. The Brennan Center has been tracking voter restrictions for over a decade, and just this last year, we've seen a 1/3 of all voter restrictions that have passed in the last decade happened in the last year, and this is related to the threats in election administration as well. It's all part of a campaign, the big lie, that the 2020 election results couldn't be trusted, that election administration can't be trusted. And at the end of the day, if we're going to really tackle this problem, what we need is clear rules about when people can vote, how they can vote, and when votes will be counted. And there needs to be a way to enforce those rules. And the way to do that is to pass something like the Freedom to Vote Act, the Voting Rights Advancement Act. And if those two things are passed, even if you have this threat of election sabotage, I'll call it sabotage, not subversion, you're going to have clear rules and a remedy. And at the end of the day, that's what we need.
The only addition that I have is that the Freedom to Vote Act doesn't mention voting rights, yet we couldn't even get a vote on the floor when it was introduced. In fact, as the last 2 years I've spent in DC advocating for voting rights and election rights and voter protection stuff. And what I saw is that when you try to go across the aisle to individuals from Republican states, often what was told was, you know, either they haven't read the legislation or they just weren't willing to discuss things with individuals. So for an elected official to have the position that they don't want to even discuss something, and that something has to do with why they're in office, how they get into office, and the fact that they all took an oath to uphold the Constitution, which most state constitutions provide access to those residents of that state, says a lot. So to point on what Lawrence just noted, I think it's a myth that if it says voting rights in it, then it's a non-starter, or that's what's delaying things. The reality is we now live in a time where if you do a soundbite and that soundbite sounds good and it sounds aligned with whatever your party lines are, that's what folks are going to do instead of working on bipartisan legislation. And the reality is the Freedom to Vote Act, similar to the John Lewis, the Voting Rights Advancement Act, neither one is perfect. And there's a lot that was compromised by advocates and allies. And it's really just a piece of legislation that provides basic support for our electoral system as well as for our citizens to have access to the ballot.
Jorge, thank you for that. I wanted to ask, I know Mimi, you need to, you're going soon, and I just wanted to ask you one question while you were still with us. You had talked about some of the things that you are working on and fighting in Texas are things that erode the very sort of foundations of our democracy, and you invoked your daughters and talking about what they would learn, which echoed to me what I heard from Jorge talking about how democracy is a learned experience. And so I'm wondering, how do we teach young people, and how do you teach perhaps your daughters about democracy, given the situation that Dana described in, poll settings that sound increasingly volatile and possibly dangerous?
Whew, that's a hard one. I mean, I'll say, I have actually taken both of my daughters, I guess before COVID, but since they were very, very young, to political rallies and events. Dana's nodding. I know she's seen me at some of them, protests of all kind. And I will say this summer around the SB1 bill, there were really moving rallies outside the state capitol. And as Representative Gonzalez said, people from all over the state and all walks of life, but as some of them, there were people who showed up in paramilitary gear. And, it's pretty scary. And I really asked myself, whether it was responsible as a parent to take my children to that environment, which that right there is an erosion of our democracy. I mean, it was, people, I know I wasn't the only person thinking that it was scary and dangerous to go speak out about our constitutional rights. And I also think that, it's the fear, the confusion, quite frankly, this message from the government that you or someone that looks like you, some of the points that have been made are not wanted at the polls. All of that is really dangerous. And it is, quite frankly, very hard to combat. I think some of the best things that we've been able to do, honestly, are creating a broad-based movement. And, I was really proud. We had people at the Capitol this summer. I know, a woman who was, clutching some of TCRP's materials there to testify, nervous on behalf of one of her kids, who's a person with a disability who would be treated like a second-class citizen under the bill. And I think that is the only way we can restore faith in democracy, is give people the tools, make it as safe as possible. Something we say at TCRP is we are lawyers for the people, that we want to use the power of the law for communities that have historically not had that power on their side. So, all of that together, I think, is the best thing that we can do. And, I agree with some earlier comments that obviously lawsuits are not everything, but at TCRP, for instance, we are bringing a lawsuit under the Ku Klux Klan Act against some perpetrators of political violence. And we are going to continue to do whatever we can to hold people accountable to try to deter that sort of behavior in the future. So, unfortunately, I don't think there's no one thing that we can do, but I do think all of this is being watched by future generations, and that we have to be very active and vigilant right now in our democracy.
Mimi, thank you so much for that. I want to go back to you, Dana. We have, for those who have not heard your story about your fight with the Attorney General, could you tell us what you've gone through in recent months, and how you stood up for voters?
Thank you. I'm happy to share the story. What happened was I told you part of it about the mistreatment of the workers and employees who were trying to work in the counting station. And I was trying to defend them against being infected from COVID. And it was a knockdown, drag out fight. I put my foot down and said, you cannot get more than 6 feet close to these people, and you have to wear a mask. And they were all determined that they would stand on top of these people without masks and breathe on them. And so it wasn't pretty. Ultimately, and I got sued. And ultimately, we worked out an agreement where the county attorneys, not my personal attorney, county attorneys came up with an agreement with the Republican Party that they should do all the things they were supposed to do in the first place, which was wear a mask and maintain 6 feet distance, unless they wanted to see something that was right there, where the person was, and then they could walk up to the person, stand next to him for a few minutes, and then back off 6 feet. And what the agreement called for protection for the employees was absolutely nothing. So given those circumstances, which I was completely livid over, I dressed my people in full hazard suits. It was the only way to protect them. Now, given that loss in that circumstance, because I consider that lawsuit a complete loss for all employees who are trying to volunteer and do good things for democracy, working in a counting station. But the next thing that happened was that the Attorney General indicated that that he was shopping around the counties around Travis County to find a grand jury to indict me on criminal charges. The number of charges was unclear, but whether it was going to be felony or misdemeanor was unclear. But what was clear was that they were going after me and that I needed to hire attorneys fast. And I needed 2 attorneys, one for election law purposes and one for criminal defense purposes. And that the criminal defense attorney had to take the lead on the case because that was the more critical part of it. And both were very well known. You would know their names if I told you. Chad Dunn was my election defense attorney. Everybody probably knows Chad. So I was lucky to have them. That was $75,000 to me in their legal fees right off the bat, and they were kind in their fees to me. It was months of constant haggling with the Attorney General's office. And in fact, he did shop it around and took his case without the benefit of a district attorney. He took it individually to, did it himself, which has just been declared by the Court of Criminal Appeals to be unconstitutional. He took it directly to a grand jury himself and lost. That grand jury in that neighboring county decided that, in fact, I was to be no billed, and I would hope that what they saw was, in fact, that this was a case of projection, that in fact I was the one who was being suppressed, not the other way around, that I did nothing to harm any of their so-called poll watchers at all. And that decision came down on April the 19th after it was filed somewhere in the very early weeks of 2021. However, I did not find out about it because it was not handled through proper channels, through a DA and through the district clerk, until the middle of July. So I did not find out that I, in fact, had been no-billed until months later. And I did not find out until a couple of months after that, because I was no-billed, I was then qualified under the risk management insurance policy in my county, that county government could reimburse me for the $75,000 in legal fees that I had been out. So ultimately, I did, not have to pay money. And ultimately I was no billed. So it came out as in a very positive way for me. But standing up and fighting back against them was in a climate where he was trying to intimidate me and trying to financially bankrupt me because I stood up to their unconscionable, attempt to intimidate the workers in the counting station.
It is a shocking and traumatizing story.
If you'll excuse me, I forgot to add one more thing. I was not allowed to speak about this at all while it was going on. So on top of being falsely accused, I was also censored. It was the most alone I had ever felt in my entire life.
I'm so sorry. And thank you so much for sharing that story. It certainly highlights what a challenge it is for people to enter into this field and do this work. What would you say to your successor and to people who are going to be carrying this torch forward, since you are preparing to step down from your role?
Right. I did not step down because of this. I stepped down for some other personal reasons. Ken Paxton is not going to chase me out of town. And the woman who is running, the front runner who is running to take over my office has more spine than I have. She will be fantastic. And so I'm very much looking forward to her. And the team that I've set up here in the office to take over just in the few months at the end of this term will also be very strong, and they will be able to stand up for voters, because I do think the voter approach to elections is the correct one. So I think it's all going to be fine. And what I would like to continue doing after the end of this month is I want to continue working on elections. I can be a volunteer. I want to work with Larry. I want to work with a bunch of other folks, who deeply care and are just as frightened as I am about this critical juncture in our democracy. I'm scared we're about to lose our democracy. I'm worried to death about it. And thank you for allowing me to take these last few minutes to share this story. In trying to take care of my mental health, as Madam President of the New York Bar had suggested as we began, I was reading Jane Goodall's book, Hope. And in the book, she tells a story about the difference between the optimist and the pessimist in today's world. And I will share that quick little story with you. The optimist is the one who looks around and says, what we've got here is pretty darn good. I'm not sure that we can do all that much better. We're doing really very well. And the pessimist looks at the optimists and fears that they're correct.
Bridget, I wanted to say something to build on Dana's comments. A lot of people had a lot of good suggestions for because this is very frustrating conversations, I'm sure for a lot of people, what people can do. One thing that people can do is thank election officials like Dana. I was just down with some election officials in North Carolina, and they were talking about how much it meant to them to hear from their constituents. And I think, we often don't think about people who are sacrificing so much to make sure that our elections run smoothly and that we can vote. And so thanking them and like many others, Dana's office is an elected office. Most election officials, not in New York State, but most election officials run for office and making campaign contributions to not just in your state, but around the country, election officials who are committed to nonpartisan administration, to voting rights. That's another thing that we can all do.
Larry, thank you so much for that. We have, Catherine, do you want to give me a time cue here? Because I know that we've run over, but I'm not sure how much. I know this group could continue talking, but I'm also mindful of everyone's time. And so I guess let me open it up and see if anybody has any final comments or, I thought it was really wonderful that Sheila Boston talked about how this was the bar of hope. So given how heavy and hard and how much work there is for everyone to do, if there's anyone who wants to make any final comments about hope for the work ahead.
Well, I'll just say that this is a participation contact sport. And that means that we don't leave things up to chance and that this isn't beyond our reach. We can do it. We actually have the power to do it. Those who oppose democracy, those who are expending every resource they have to destroy what has been built in this country can be opposed by those of us who believe in our democracy and who believe that we should not be ceding ground to those who wish to destroy us. And so I am hopeful. I know that this is a despondent time and that there's so much going on. And I think, we have a once in a century pandemic that influences everything that we do. There's so much happening, but I am hopeful because this country's not perfect, but we've done this before. After every time they've tried to restrict, we have fought back. And when I say we, it has been the people that have done this, and we've been victorious. And so this is your moment. This is your textbook moment. There's going to be 50 years from now, 100 years from now, hopefully, if we battle climate change, where people will look back and say, what did you do when our democracy was at stake? All of us on this call, I hope, are going to be able to say that we fought back and we were victorious. So we can do it, and I'm hopeful.
Thank you, Senator Myrie. Is he the only one who has hope?
I think he said it all.
That's a hazard of the job, that you got to be hopeful.
Wonderful. Well, thank you so much. I want to thank the New York City Bar Association. I want to thank this incredible panel of experts. We were moving along in the beginning, and so I didn't get to give my warning, which is, as a reporter, now that I've met you, I'll definitely be calling you. I can't wait to talk again. Thank you so much for your expertise, for your work, and I look forward to talking more in the future.
Thank you so much, Bridget, and thank you to the wonderful participants. And thank you, audience, for staying with us and for doing all you can do. Thank you so much. Good night.